The emergency proclamation and emergency measures regulations severely restricted the rights to freedom of expression, assembly, and association. The Emergency Economic Measures Order chilled freedom of expression by deterring donations to organizations opposed to the public order emergency, such as the CCF. For the CCF, the fundamental question is whether the condition in the final clause of Section 3 of the Emergencies Act was met, that the Ottawa protests and border blockades could not be effectively dealt with under any other law of Canada, federal, provincial, or municipal. This clause codifies the requirement that the Emergencies Act is a last resort, which can only be triggered when all other legal tools fall short. Third, although the Commission will necessarily focus on recent events, a sense of history should frame how it approaches this task. The Emergencies Act is a successor to the discredited War Measures Act, which was abused during the FLQ crisis in Quebec. The Emergencies Act, especially the last resort clause, was drafted to ensure that the Act could never be used by a federal government against its political opponents. For 34 years, the Emergencies Act was never used. The public order emergency of 2022 was a historic first. But now that the glass has been broken on the Act, it can be used again. The Act was used by this government against individuals protesting vaccine mandates, but a future government of a different political stripe could use the Act in response to protests against pipelines or climate change. When the Commission asks hard questions about the Act's use in 2022, the Commission must also focus on the Act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. And what the Commission says matters not just to Canada, but globally, where the use of emergency powers is on the rise. The world will be watching our work.